Hello, and welcome to Teaching American History's Saturday webinar, a webinar and podcast series that explores controversies of American history. Today, we are joined by our host, Jason Stevens of Ashland University, and panelists Adam Seagrave of Arizona State University and Jason Jividen of St. Vincent's College. In honor of Constitution Day, we've chosen to focus this episode on the relationship between slavery and the Constitution. Join us as we explore the question, is the U.S. Constitution a pro-slavery or an anti-slavery document?
Hello and welcome. Happy Constitution Day. My name is Jason Stevens. I'm Assistant Professor of Political Science and History at Ashland University, and I want to welcome all of you here today with us. Welcome to our September episode of this year's Saturday webinar series, American Controversies. By bringing together thoughtful scholars with differing points of view, we hope to have a discussion, a conversation about historically important issues that still resonate in the current classroom. We encourage all of you joining us today. I see people are still filtering in. We invite all of you today to participate in that conversation by submitting questions via the Q&A box. Not the chat box, but the Q&A box. Please submit any questions you have there for our panelists. We'll try to get to as many as possible in the next hour and 15 minutes or so. Within the next week, you will receive an email with links for further reading, as well as a link to the archived video and audio from today's program. In the registration form, we have already linked to the speeches, the letters, the other documents and writings that we're using as part of today's conversation. Many of them are also available at the Teaching American History's extensive document database located at tah.org or in our core document collection. Today, we will be discussing, is the Constitution an anti-slavery or a pro-slavery document? A very important question for all days, but especially on this day, Constitution Day. Joining me on our panel is Adam Seagrave. He is an associate director and associate professor in the School of Civic and Economic Thought and Leadership at Arizona State University. Adam, welcome. Good to see you again. Also, our old friend, Jason Jividen is here. He is an associate professor of politics in the McKenna School of Business, Economics, and Government at St. Vincent College. Both are also faculty members in Ashland University's master's program in American History and Government. They've been teaching in that program a long time. They are fantastic professors. I've seen them in the classroom. Their students just love taking classes from these two gentlemen. We are so happy and lucky to have them with us today to be part of this conversation. Gentlemen, welcome.
Thanks, Jason. It's good to be here.
Yeah, thanks, Jason. Likewise.
Now, before we get started, all of our attendees, I see the numbers still going up. Many people still joining us. Before we get started, we're going to take just a few minutes. Could all of you joining us please take just a moment or two to answer the two questions that should now pop up on your screen? Our staff at TAH is trying to get a sense of what type of professional development we should offer to our webinar participants. And so your feedback will really help us determine how to best serve our teacher audience. So please take a few minutes to complete this survey, and we'll go silent in the meantime. We'll come back in just a couple. Okay. For those of you still entering the room, please make sure you fill out those questions on the survey on your screen. And I think you'll also have another opportunity at the end of the program to do that as well. As you continue to do that, we're going to get the conversation rolling here. Gentlemen, again, thank you for being here. We're going to get let's just get the ball rolling on this very important question for Constitution Day. Is the Constitution a pro-slavery or an anti-slavery document? So just, a broad opening question. Why is this such an important question for teachers and students, but really all Americans to think about, to think seriously about? Why is this a question worthy of our attention? And any
Well, I'll just get us started, and I'm sure Adam has a lot to offer here. I'll just start with a sort of an anecdote. We're college educated people. I through my education as a young person, especially into taking history and politics courses, as an undergraduate, I remember very distinctly, especially in educational institutions, a notion that there's something about the American founding, the U.S. Constitution, because of what was perceived as its compromises with slavery, that rendered those institutions problematic and perhaps even not choice-worthy. And so I think when we're talking on Constitution Day about inheriting institutions, perhaps maintaining or passing on institutions, we have to think about what it is that we're maintaining. And if there's an argument out there that the institutions we're maintaining are fundamentally problematic or even rotten to the core because of a compromise with a clearly evil institution, what does that mean for us as educators? What does that mean for us as citizens? How should we understand those institutions? And if we think they are choice-worthy, we have to understand what those compromises were. If we think they're not choice-worthy, we have to understand exactly what it is we're critiquing. And so I think to understand the character of those institutions, especially on a day like this, we need to sort of get right with the history. What is the relationship between the Constitution and slavery? We have to have a clear-eyed vision of that before we can even think about preservation or change or really even criticism. And so I will just say in my experience, the more that I read the Constitution, the more I read things like Madison's notes on the convention, the more I read some of the issues surrounding the 1850s and the coming of the Civil War, the more I read issues surrounding the Civil Rights Movement, I came to understand that Constitution better. And I think, at the risk of sounding arrogant, just have a bit of a more nuanced view at some of the questions that are on the table. And as an educator, that's all I would want, just to help to bring those questions to students and help us seek out the answers to them. So I think it's a crucial question because at the end of the day, we're human beings and citizens, and there are duties incumbent on us in both those roles. And that requires us to think pretty seriously about slavery in the Constitution. But Adam, I don't know what you'd like to suggest there.
Yeah, no, I agree with all of that. I think those are really good points. I would also say that I think the Constitution is bound up with American identity in so many ways. It's really at the core of American identity. And so I think how we think of ourselves as Americans, right? Do we take pride in that? How do we reflect upon that, upon what it means to be an American? I think that what we think of the Constitution is a big part of that. So how we assess its value with respect to slavery. And I think if, the American experiment in self-government, right, its importance for humanity, if we're going to value that, I think it really makes a big difference whether slavery and racism were, so to speak, baked in to the original founding principles and documents that define the American experiment in many ways. So I think the stakes are really, really huge because slavery was so bad, right? So it's not as if this is a minor evil we're talking about. It's a really, really serious injustice and evil. And so if it was actually supported or endorsed in the document that perhaps more than any other, along with the Declaration of Independence, defines our identity as Americans and defines the meaning of the American experiment for humanity, then that's a really, really serious issue. It goes back to what Hamilton said in Federalist One and what John Winthrop said on the Arbella, that if America is going to have some kind of meaning for humanity and some kind of positive contribution to humanity, it's vitally important that we assess accurately and appreciate what's of value in the American founding. So answering this question about the Constitution, I think, is a really crucial part of that.
Yeah, those are all really, really good points. right, especially to keep in mind on this, the 235th anniversary of the Constitution. If this is a pro-slavery document, if slavery was baked into it from the beginning, so to speak, then why continue to celebrate it? So maybe we can come to better understand America, better understand the Constitution, and why Constitution Day is a day worth celebrating. Over the course of this webinar, we're already getting several very interesting questions coming in from members of our audience. So I'd like to get started. In fact, one question here I think will be a great way to sort of dive into the text that we've selected, especially the Constitution itself. So one of our participants asked, certainly the 3/5 clause is dehumanizing, but was it also an attempt to limit the influence of the Southern states in the House of Representatives? That's the question. So why don't we remind ourselves of what the 3/5 clause says? So I'll just read here directly from the Constitution, and then we want to consider, right, is this dehumanizing? Is this an endorsement of slavery? Is this a pro-slavery or an anti-slavery clause? So here's what the 3/5 clause says in Article 1, Section 2, Clause 3. Representatives and direct taxes shall be apportioned among the several states, which may be included within this union according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. Jason, Adam, can you help us understand that?
Adam, you want to get started there?
Sure. Yeah. So, yeah, the question is a good one, right? So on the 3/5 clause, I think of it in terms of its denotation or its factual meaning, and its sort of its meaning as a compromise that was worked out between delegates of the Constitutional Convention. So kind of the technical meaning of the clause, and then also the connotation or the symbolism of it, right? With the 3/5 being dehumanizing to people who were counted as 3/5, right? Primarily, we're talking about African-American slaves at the time. So I think thinking of it in those two ways, that first of all, it's significant to note in this clause, as in the others in the Constitution, that enslaved African Americans are referred to as persons, right? And that's something that Frederick Douglass and Lincoln, of course, make a lot of, and I think made good arguments regarding that. That's a really crucial point, that they're referred to as persons. I think that in terms of the number itself and the compromise that was reached, I mean, that number was in existence before the Constitutional Convention was in place under the Articles of Confederation. So the debate was not, well, of course, it was between Northern delegates who wanted to not count enslaved people at all, right? Count them as 0, and Southern delegates who wanted to count them as 1. So looked at that way, and I think historically as well, the 3/5 clause was certainly supportive of the Southern slaveholding interest and power in Congress. I think it was net positive in many ways for the South. So I think practically speaking, it was a victory in some ways for the Southern delegates and Southern states, I would say, and of course the symbolism has been important in American history. But having that reference to persons in there, I think, is absolutely crucial as well, and goes on the other side to be a victory for anti-slavery delegates in the Constitution.
Yeah, I just add a couple things. I think all this is really well said. I think it's important to note that this clause is often, I think, misunderstood sometimes by politicians, by rhetoricians, even by teachers, textbooks. It's really important to note that 3/5 number was pre-existing. There was a proposed amendment to the Articles of Confederation on taxation. That's where the ratio came from. It wasn't pulled out of thin air. In some ways, it was seen as being a sort of moderating influence, that we're using something we'd already talked about, a kind of, I don't know what other word to use, but the moderating. But it's important, I think, especially for students and those of us who are teachers, to impress upon students that we're talking about. Rarely do you hear folks, so in fact, you don't see it at all, say in Madison's notes or in ratification debates, anyone referring to slaves as 3/5 of a human being. You hear people sort of make that mistake in talking about this clause. No person in their right mind would ever say you're either a human being or you're not. What they're talking about is 3/5 of the total slave population for purposes of representation and direct taxes. And so it is a compromise. I think Adam's exactly correct to say that it gives some real strength to the Southern slave interests in Congress in a way that had those slaves not been represented for representation, it would not have happened. But I think a really important point that Adam made is that language of persons. Frederick Douglass tirelessly made this argument that in all the places where the word slave or slavery could have been used in the original unamended Constitution, the writers of that document deliberately chose to use different language. And so they very deliberately referred to the slave population as persons. And I think one thing that really bears out the importance of that is one of the readings we had was the Dred Scott decision. And in trying to make the case for a pro-slavery reading of the Constitution, Tawney points to the Fugitive Slave Clause, and he points to the Importation Clause. He avoids the 3/5 clause as much as he can because it actually contradicts the point he's trying to make, which is that slaves were not considered persons, they were considered property. You don't represent property, you represent persons. And so the 3/5 compromise actually undercuts the argument that Tawney's trying to make. And so I think that's something worth paying attention to. And Adam's exactly right to point out that language. It's just crucial.
Yeah, I would just quickly add to that too. Just Federalist 54, I think, is a really crucial follow-up reading to this question. Also, it's where Madison is wrestling with the 3/5 clause, and of course, it's a very interesting Federalist essay in so many ways in terms of the style and presentation. But he explicitly deals with that conflict between being a person and being property in Federalist 54 in a really illuminating way, and I think a way that points out and highlights that contradiction, implicit contradiction in the discussion in the Constitutional Convention between, are enslaved people, are they persons or are they property? And then I think they're consistently treated as persons in the Constitution, with that underlying contradiction in practice of treating them as property where they're enslaved in the Southern slaveholding states. So Madison in Federalist 54 really wrestles with that in an illuminating way.
I just actually taught Federalist 54 this week here at St. Vincent's, and
Yes.
I was pointing out to students that even there, Madison has a hard time supporting the compromise in his own name. When asked about it, he says, well, it's favored by many of our Southern brethren. He doesn't defend it in his own name. In fact, he's suggesting that the Deep South would never sign on to this Constitution without something like it. And so I just think that's fascinating. I often tell students, imagine if you're praising something but not attaching your own name to it. Why are you doing that? And so just the rhetoric of 54 is fascinating to use in the classroom.
Yeah, all very, very interesting points. Jason, what you said about Roger Taney and the Dred Scott decision, that I think is still today, you guys correct me if I'm wrong about this, that's still the longest Supreme Court decision ever issued by the court. I believe certainly it's most infamous, but I think it's also has the record of being the longest.
I don't know, but that's very plausible because it's extremely long.
It's extremely long, yeah. But even in
yeah.
that entire long opinion written by Roger Taney, he doesn't talk about the 3/5 clause very much at all, right? To make that case that the Constitution's a pro-slavery document, he talks a lot about the Fugitive Slave Clause, a lot about the slave trade clause, doesn't mention the 3/5 clause. That's strange. If the 3/5 clause really was a pro-slavery clause, you'd think Taney would mention it. Yeah. And then on the other hand, as you mentioned, right, Frederick Douglass, when he reads the Constitution, I think Douglass, he didn't like calling it the 3/5 clause. Douglass preferred to call it the 2/5 clause, right? Because he says it leans towards freedom. Even taken at its worst, it still leans towards freedom, which is so interesting and may strike some of us as strange that, right, Frederick Douglass, the former slave, right, the escaped slave, looks at the Constitution. And he doesn't see, at least later in his life, right? He changes his mind at one point in his life, but later in his life, the mature Douglass, the one who's writing during the Civil War and writing the documents that we have here before us, Douglass sees the Constitution as this great liberty, anti-slavery document. I was just wondering if either one of you or both could comment on Douglass and his thoughts on the Constitution.
Well, I'll just chime in real quick. I think this piece that we read for this webinar in particular is fascinating because right out of the gate, he draws this distinction between the intentions of the folks who wrote the document, the intentions of the folks who were at the conventions, and then the text of the document itself, which is absolutely crucial because in some ways, he's giving up to the other side. Okay, perhaps we could find a slaveholder in this particular convention or someone with this motivation where 3/5 would line their pockets and aggrandize their power. He would say, well, maybe we can concede something to that. But what we're talking about is the text of the document that they handed down, that we received. the one that has been purged of any explicit reference to slaves or slavery, the one that does count slaves as persons, the one that does give Congress the power to abolish the international slave trade after 20 years, right? There are all these things in the Constitution that the text suggests that there's a moment looking forward where slavery will be abolished. And so whatever one could suggest about the motivations of people who are at the convention or the motivations of slaveholders, what we're dealing with is the text itself. And so, Jason, I think you're exactly right. This famous phrase that he mentions in several speeches, that the Constitution is a glorious liberty document, that when read properly, and you're exactly right, later in his career, this becomes a more full-throated defense, but that it's a glorious liberty document that actually points towards the end of slavery, not in any way towards the perpetuation of slavery. And so so much of these speeches that Douglass makes, especially as he becomes more confident in this argument, I think are all about how we interpret a text. And so for students of the Constitution, for students of constitutional law, how we interpret text, you can really do a lot worse than reading Frederick Douglass. It's fascinating. And he's also very creative in some ways. There's some things that maybe we could dispute, debate. I think his reading of the 3/5 clause is correct. I think his reading of the importation clause is spot on. The one that sometimes always strikes out to my students is this discussion that slavery is a bill of attainder. We know in Article 1, Section 9 that bill of attainders are prohibited. The idea that you would have sort of a summary conviction of large groups of people based on accidental characteristics, et cetera. I know legal scholars have disputed that, but it's something that Douglass often argued in public. But I'll defer to Adam on some of these things.
Yeah, I think those are all great points. Yeah, I think Jason's absolutely right that it's a brilliant reading that Douglass gives to the Constitution in terms of separating out the text from the context. And I think that it makes sense, of course, because the Constitution itself was written collectively by people who disagreed with each other on many things, and particularly on the issue of slavery. So it makes sense to look at the text of the Constitution as its own thing. In other words, they're thinking about original intent, right? There was no single original intent with respect to slavery in the Constitution. That's, I think, the simple fact of the matter. There was disagreement about this, and so all we can look to is the text itself. And I think on that point, I think Douglass makes an absolutely compelling argument that if you just look at the text itself, it clearly does contain principles and purposes that are opposed to slavery and doesn't do anything to uphold the existence of slavery. In fact, even to the point that, there's a question whether the 13th Amendment was needed at all in terms of, do we need to amend the Constitution to outlaw slavery? I mean, really, no. And I think Douglass would, makes a compelling argument on that point. The Constitution is anti-slavery in the text itself. But I think that I'm always, I love teaching Frederick Douglass side by side with William Lloyd Garrison, because I find Douglass's argument so compelling about the text of the Constitution. But then I also find Garrison's argument so compelling about the context of the Constitution in many ways. Garrison much more compelling than Justice Taney, for example. I think Taney just makes an obviously flawed argument about the context and history of the Constitution. But Garrison, not so much. I think Garrison, he takes, of course, a very different reading of the Constitution, namely in terms of the delegates to the convention and the opinions of the time, and the Constitution in its sort of performative aspect, if you will, of forming a union. And it's just a different way of looking at it. I mean, you could say that Douglass is actually looking at the Constitution, whereas Garrison is looking at the circumstances surrounding the Constitution. But I love teaching those two side by side, because I think they do both in their own way give very compelling arguments, but of course, that point in exactly opposite directions.
Yeah, those are all really great points. I really hope we get a chance to talk about Garrison more during the course of this webinar. But I'm noticing we're getting a lot of questions coming in through the Q&A function here. So folks, keep them coming. Maybe just to go back a little bit, because I'm seeing a couple of questions dealing with sort of the context of the compromise and where that 3/5 number came from and what its aftermath was. So I want to try to maybe sum up or summarize a couple of these questions and maybe combine them into into one. So Jason, I know you mentioned that 3/5 number was nothing new at the Constitutional Convention. It had actually been borrowed by the Articles of Confederation. But we have a question here about how they arrived at that 3/5 number in the original discussions during the Articles of Confederation. Then we also have another question about, well, what was the eventual outcome of the 3/5 clause? Did it prevent the South from attaining more political power or not? What was the political impact then of the 3/5 clause, say maybe in the first Congress?
Yeah, I'll just get it started. I maybe Adam does know. I don't know a lot about the history of the debate where that 3/5 number came about for this proposed amendment to the Articles. It actually failed, by the way, that amendment, as I understand it. It was in the sort of the 11th hour of the Articles. In terms of the immediate and really long-term impact all the way into the 1850s, I think Adam said this earlier. I do think that the 3/5 compromise aggrandized the power of the slaveholding South. I do think that it gave them in some ways a leg up in Congress. And I think that if one is going to make the claim that there were compromises of slavery in the Constitution, that at least was hopefully perceived to be in the short term, but turned out to be longer term than they expected, the 3/5 compromise really did add to that problem. It gave more voting power to the slave interest. And so I think it does eventually take abolition, right? It takes the 13th and 14th Amendments to remedy that problem. There are folks who would argue, there you go, there's a smoking gun, right, to show that this is a constitution that is a pro-slavery document. But here we have to contend with Douglass's arguments. Think about what you have there. It is really a compromise. Should we think of it rather as the 2/5? Should we focus on the fact that it refers to persons? Should we focus on the fact that it did, at least in some ways, moderate would have been even an even toothier slave interest or slave power in the Congress. So it's very much a compromise, and like all compromises, I don't want to sound flippant, but there's a half full, half empty problem here, that no compromise is going to give us exactly what we want. And so there is a real dark side to that compromise. And I think it helps, frankly, it helps lead to the slave expansion crisis of the 1850s and eventually the Civil War. I don't know what you think, Adam.
Yeah, no, I think that's right. Yeah, and I also don't know a lot about the background of how exactly 3/5 was arrived at the number in the original debates under the Articles of Confederation. I'm not sure how they arrived at that number. So that would be worth looking into more deeply if there's available evidence. I haven't read anything about that either in terms of why 3/5 as opposed to a half or some other fraction. So that is an interesting question. Yeah, and I do think that if we're talking about representing persons rather than property in Congress, that was a question during the Constitutional Convention and prior, of course, and even following to some extent. But what's represented, or what should we represent in Congress, persons or property? And the decision that came out of the Constitutional Convention was, as Jason said, that we're representing persons, we're not representing property in the House of Representatives. And of course, in the Senate, we're representing states, right? But so given that, I think it is easy to see the 3/5 clause as a victory for the Southern states, because of the fact that that enslaved people are not, they have no voting power, they have no influence, right, on the political process. So why are they given a share, accounting, in representation at all? And also the taxation part of that clause was not really much of a counterbalance. So that didn't end up really being a weapon, in the hands of northern states or of the Union in curtailing the slave interest in the South. So I think Jason's right that historically, and as it played out in the effects of the Constitution, the 3/5 clause definitely did increase the power of the Southern slaveholding interests in Congress, and was an important benefit that they received. But yeah, it is part of this debate during the Constitutional Convention of do we represent persons or property? And even though it comes out at the end that we represent persons, the 3/5 clause is sort of it doesn't fit well with that, because enslaved people are treated as kind of a mixture of the two, as Federal 54 says. So yeah.
I just want to chime in too, just to make sure that we cover sort of the waterfront here, at least in my experience, and shout me down if you think I'm wrong. A lot of folks who critique the Three-Fifths Compromise from our vantage point today often suggest that there's, again, we've used the word dehumanizing, but we should be clear about in what respect it's dehumanizing. Some people, I think, if you follow out that logic, for some folks, well, surely all slaves should be counted for representation. That would be humanizing. Well, think about what the net effect of that is. Then you're giving much more power to the slave interest to perpetuate slavery. The humanizing thing to do will be not to represent slaves in terms of proportionality for Congress, because then you would be depriving the slave interests of the very power they need to perpetuate slavery. And so I think there's often a profound misunderstanding of what the Three-Fifths Compromise is doing. I think the real critique would be not that slaves weren't counted. I think the critique should be the fact that they counted slaves at all. If you're suggesting that we want to be anti-slavery, then we shouldn't be representing slaves in any capacity, which is what many Northerners had said. I mean, remember, this is a compromise. There were many Northerners who said you should not represent slaves. They're not citizens. They don't vote. You said in every other respect, they're property. We don't represent hammers or wagons, right? On the other hand, you have the Southerners who, there's an irony here, who have for all the time said they're property and suddenly start suggesting these folks deserve to be counted for representation because they contribute to our community. They're part of, and frankly, they're part of the people. And so you have this very strange argument going on that we, I think, in a lot of ways today misunderstand. And the most humanizing thing to do would be not to count them at all in this particular context, which I think for some folks, they haven't quite thought that through yet, at least in my opinion.
Yeah, that's a great point, Jason. Just to chime in there, it's sort of a damned if you do, damned if you don't sort of situation in that way, right? Because either way, it's a problem, right? Either the text of the Constitution accurately represents the personhood of enslaved African Americans and thereby increases, magnifies the practical power of slaveholders over their slaves, or you count, or you don't count them at all as persons for the sake of representation, and then that's symbolically dehumanizing because you're excluding them. But if in practice, that would of course favor the abolition, the anti-slavery cause. So it's really there was no clear right way to handle this, I think, practically in the Constitutional Convention.
That's a fantastic point. It points to something that Adam brought up earlier, that when we're talking about a constitution, we're both talking about questions of principle and identity and how it comes to be understood, how we understand ourselves, but it's also a very practical political document that is being written at the time to address very real practical political problems and trying to, and I think a lot of times politics requires like kind of prudence and compromise that documents like that necessarily have to entail, whereas when we're talking about identity, we're often in the realm of principle. Where I don't want to say we're not prudent in thinking about those principles, that sometimes compromises with principle are perceived as being detrimental to identity and to truth and justice and dignity.
Yeah, such a powerful point. I think that if the Three-Fifths Clause hadn't been ratified as it had been, that is to say, like, let's say if there hadn't been a compromise, the northern states had just totally given into the southern states' demands to count the slaves as whole persons. I think in the first Congress, then the southern slave states would have been the dominant force in that first Congress. Whereas with the Three-Fifths Clause, the northern free states are in the majority in that first Congress, which it's that first Congress that passes the Northwest Ordinance, right, which keeps slavery out of the territories, out of the future free states of Indiana, Illinois, Michigan, Wisconsin, and Ohio. So politically, the Three-Fifths Clause, maybe at least initially, was able to limit slavery, keeping it from spreading into the territories. But it sounds like it was the result of, as both of you gentlemen have mentioned, as a result of compromise, of prudence, of dealing with practical politics as it exists in the here and now, not as we wish it would exist. And so we have a question just from one member of our viewing audience here about sort of that context. What is the context of slavery as it exists in the United States and the world at this time in 1787? Because slavery doesn't just exist in the United States. It exists everywhere and has existed everywhere since the beginning of time. How can we best distinguish between American slavery, this viewer asked, and other forms of slavery, thinking about Romans and other cultures?
I'll start off that one. That's a big question, an important question. So for one thing that I think is relevant to this, one point to this question that I often think about is in the convention debates on August 21st. That's one of the readings for today's webinar. There's a line that Charles Pinckney of South Carolina uses, and he says, "If slavery be wrong, it is justified by the example of all the world." Right, and so that explicitly becomes a part of the debates in the Constitutional Convention about, about the wrongness of slavery. And I think it's true, as Lincoln said later, noticed later, that nobody argued that slavery was a positive good in the Constitutional Convention or at the time. Nobody argued that it was a good thing. But the furthest they argued was what Pinckney argues, namely that it's everywhere, and it's been around throughout human history. And I think that in a way, that's true, of course. But also in the American context, that history and that sort of this is the way we've always done things really ran up against the principles of the Declaration of Independence. It just ran into a brick wall, and I think that was the real problem, or at least that was a big part of the problem, is that brick wall had not been there in the same way in human history in the past and in other parts of the world, that we have this principle that now is explicitly and directly opposed to this practice. So I think that's the first thing to notice, and that the Southern delegates really don't get. And at the very beginning of that August 21st debate about the Slave Trade Clause 2, you have this really illuminating exchange between Luther Martin of Maryland and John Rutledge of South Carolina, where Martin brings up the moral point about slavery, among other points. And then Rutledge says, interest is the governing principle with nations, right? It's not religion or morality, it's interest. And that always brings me, I think it's a microcosm of the Melian dialogue, if you're familiar with that, right? The ancient Greek, the Peloponnesian War, right? Athens and Milos. And it's exactly that all over again, that we're not talking about morality, we're talking about interest. So I think that the problem was, in the American context, at least a big part of the problem, was that the early American founders, for the first time in human history, as they're founding a nation, they really care about moral principle. They really, really care about it. At least many of them do, and think that we've got to found our government on moral principle, namely the principles in the Declaration. And so now you've got this issue where, you have this universal human practice, but at the same time, it's directly opposed to the principles we're trying to found our government on. So I think it's a great question and point, and I think it really does speak to the importance of the American experiment in many ways.
There's absolutely no way I can improve on that. That was fantastic. I'll just add a couple little things. You mentioned the Melian dialogue. I was thinking a bit about Socrates and Thrasymachus and the Republic, or the Lincoln-Douglas debates, because they're actually all sort of sniffing around the same territory. The thing that occurred to me in thinking about context, I was going to mention, the expectation on the part of many of the founders, including Jefferson himself and many of the signers of the Declaration, that eventually the principles of the Declaration would impress themselves upon the minds of even the slaveholders, so that we would have voluntary emancipation with the consent of the slaveholders. Look at Jefferson's queries and notes on the state of Virginia, or his description of Virginia trying to abolish their own importation of slaves, and with the Crown vetoing that. There's an expectation that slavery eventually, I think, will be strangled in the places where it exists and die a natural death. And of course, we know that's not economically how it happened. Into the 1820s, 1830s, the cotton crop becomes ridiculously profitable due to innovations in technology. And it's no accident that's when you start to see, for the first time in American history, a full-throated argument that slavery is a positive good, from Calhoun and Fitzhugh and many others. It's an innovation. And what's interesting in the readings we have today, some of the readings we looked at for this morning, they speak to that. If you notice, Tawney suggests that the opinions of Americans about slavery are improving since the time of the founding. That's precisely the opposite of what Lincoln and Frederick Douglass would argue, which is to say, no, actually, we've become less enlightened. What we've done is dug in our heels to defend an institution that the framers themselves understood was maybe at the time a necessary evil, but nonetheless an evil and never a positive good. And so and we're talking about context, there's a change in opinions that are happening. And one of the best places to read about that is just reading the Lincoln-Douglas debates. I think Lincoln really gets at this probably better than anyone. And there too, they bring up the idea, is this simply a matter of interest, or are we talking here about a matter of natural right? And to the extent that we recognize interest as part of what motivates us in politics, how do we understand that can never be the sole principle? of the American regime, because we're dedicated to a notion of natural right that's there in that declaration. And so I think context, again, these changing opinions about the intrinsic evil or goodness of slavery is part of what has been developing from from the 1760s all the way up until the 1850s.
Yeah, and I would just add another quick note to that in terms of further reading. Alexis de Tocqueville, his chapter on the three races at the end of Volume 1 of Democracy in America, I think is really great on this point about context for American practices of enslavement, and then also treatment of Native Americans. He gives a really great explanation of the historical context and of the tensions and the contradictions and the difficulties that exist in the United States in the early 19th century with respect to slavery. I think Tocqueville's really good on that. So if you look at that too, that gives some important background.
Just one final point on that. The original question was thinking a bit about the history of slavery in the world. And one thing about Pinckney's comments and some of later Calhoun's comments and others often in the US Congress, they would mention Aristotle, they would mention the Bible, they would talk about the Greeks, the Romans, but sometimes there's a conflation there of ancient conventional slavery as you would have it in the ancient world, which usually was the product of you being conquered in war. It was not chattel slavery that we experienced in modernity. And so there are two very different forms of slavery. In that ancient form, you could often buy your way out. You could eventually be released from slavery. It was all conventional. It was about circumstance. Bad luck, perhaps, but you were in the wrong place at the wrong time. Whereas with regard to chattel slavery, we have arguments there about the supposed natural inferiority of a race of people, and that they were better off being enslaved than they would be being free. And that's very different than what we see. So there's a bit of a loose argument on the part of these slavery apologists into the 1840s, 1850s.
Yeah, and actually, I'm glad you brought that up, Jason, because that's right. And that's something Tocqueville mentions too. I mean, there are differences and distinctive features of American slavery as well relative to other slavery historically and elsewhere around the world, that particularly, the chattel component and also the race-based components, the racialized slavery that is not ubiquitously the case in human history and around the world. And that makes it such that the conflict is even more intense because you have a particularly tenacious form of slavery, I think, in the American case, that runs up against of course, particularly tenacious moral principle. And so that just dramatizes the conflict and the contradiction all the more, because on both sides, you have very strong versions of either pole of that tension.
Really, really interesting stuff. You both mentioned the slave trade clause, and I know a couple of our documents deal with that. We're getting some questions in about the slave trade clause, so maybe we can go back and let me read the slave trade clause. And I'd just like to have you gentlemen comment on this and how we ought to understand this. Is this a pro-slavery or an anti-slavery clause? So this is Article 1, Section 9, Clause 1. The Constitution says this: the migration or importation of such persons, there's that word persons again, the migration or importation of such persons as any of the states now existing shall think proper to admit shall not be prohibited by the Congress prior to the year 1808. But a tax or duty may be imposed on such importation not exceeding $10 for each person. How should we understand that? What is that saying? How should we understand that clause of the Constitution?
Well, I'll just get it started. Again, not to sound flippant, but it's again back to the half full, half empty. And depending on how you want to read it. So what the clause is saying, right, is that Congress is prohibited for the next 20 years, right, essentially for the next 20 years, from prohibiting the importation of slaves from overseas, right? So the international slave trade. This is not about domestic slavery, not about anything internal. It's about importation of slaves. And so going back as far as we can, looking at the history of the colonies, into the articles, into the framing of the Constitution, anyone who ever suggested that we might want to wean the country off of the institution of slavery would understand, first, you cut off the supply. We see this, as I said before, in Jefferson's Summary View of the Rights of British America, there's a statement about this. And across the colonies, this conversation is happening. And so first you have to cut off the supply. Of course, we see in the notes on the convention that many Southern delegates, of course, are not going to go for this. We understand that the perpetuation of our economic interest depends upon further importation. We don't want limitations of this kind. So what do you have, right? You have a group of people who want to suggest we need to be able to cut off the supply of slaves from Africa. Another group saying we want to maintain it. What do? You strike a compromise. This is another compromise. And essentially, as I understand it, you're suggesting we're going to give the deep Southern slave interests, especially 20 years to prepare themselves for a very simple fact. As soon as Congress has the power to prohibit the international slave trade, they're going to do so. They're given power to do it. What makes it tricky is it's in Article 1, Section 9 of the Constitution, which is actually a statement of the limitations on Congress's power. Section 8 is the one on the grants of power. So what do? You sneak into what is ostensibly a statement of limitations that it is a limitation, but only for 20 years. After 20 years, it has the potential to become a positive grant of power. If you read it a little bit differently, you suggest it's not a denial of power, it's a grant to say in 20 years, Congress shall have the power to abolish the international slave trade. And that's precisely what they did. As soon as the clock strikes, that legislation had been drawn up and ready to go. They pass it the second they are constitutionally enabled to pass it. And so here's a good example of how do we want to read the Constitution. This is very much a Douglass versus Tawney sort of problem here. Tawney looks at it and says, there clearly is evidence for a pro-slavery reading of the Constitution. By the way, Garrison makes the same argument. Garrison and Tawney actually are in fundamental agreement on the pro-slavery nature of the supposed pro-slavery nature of the Constitution. They just disagree as to whether it's a good or bad thing. Garrison and Tawney read it as a pro-slavery provision. Douglass, on the other hand, says, no, this is actually empowering Congress to begin the process of weaning the country off of slavery. So it's, again, it depends on how you read it. Just showing my hand, I tend to read it rather than a limitation as a delayed grant of power to Congress. And I'm echoing things. That's not me. I learned that from Frederick Douglass. But Adam, I don't know what you think.
Yeah, no, I think those are all great points. And yeah, it is. It's interesting that it's a prohibition of a prohibition, right? And so it's just a very convoluted of all the slavery clauses, so to speak, in the Constitution. It's perhaps the most convoluted in that way and hard to interpret. And I think, I think you're right. I mean, you can read it clearly either way, which is to say, I think ultimately that Douglass's reading and Lincoln's is ultimately too is correct, that it's on its face and in the text itself, it's at least neutral and perhaps an anti-slavery part of the Constitution. That said, I mean, Madison in his notes, at the end of that discussion in August, he expresses, grave concern about that clause, right, and what it expresses. So maybe Madison would disagree with Douglass. I don't know, but Frederick Douglass. But I think also, so it's interesting. I mean, the slave trade. There are other dimensions to this as well. So one thing is that in the history of the transatlantic slave trade, only 4% of the people kidnapped in Africa and brought over across the ocean arrived directly in North America. It was 4%. But by the time of the Civil War in 1860, 2/3 of the enslaved Africans in the Western Hemisphere were in the United States. 2/3, over 60%, 66% or so. And so what that speaks to is the domestic increase of the enslaved population in the United States. And that, of course, is one dimension of why Virginians like Jefferson were okay, at least, with cutting off the slave trade, right? Because their domestic enslaved population was increasing just fine, and so they didn't need it, right? It was South Carolina and Georgia, North Carolina, maybe to some extent, that still needed it or thought they needed it. So there's that dimension to it as well. And that, I think, is a fact of immense importance. The way that slavery grew in the United States, the enslaved population grew in the United States through reproduction, right, rather than through importation. I think that created a dynamic in the United States that's different from the dynamic in South America and Central America in many ways. But I do think that in terms of the meaning of the clause, I think that by sort of really tripping over itself to refer to enslaved African Americans as persons again, in an even more convoluted way than it had in the 3/5 clause, and by cutting it off, at the source, as Jason says, I think that those are anti-slavery thrusts to that clause, and so I think that reading is plausible.
That's really, really good. one thing I noticed when reading through Madison's convention notes, which was one of our readings for today, early in August, when this issue of the slave trade is first introduced, right? So the Committee on Detail, right, they submit a document that originally would have prohibited Congress or anybody else from interfering with the slave trade forever. And you see the delegates from South Carolina, especially, but also North Carolina, Georgia, digging in their heels saying, like, this is a line in the sand. We're not giving this up. It will never be prohibited. The slave trade will never be prohibited, and we'll never consent to anything but that. If you try to change that, we're out. We're leaving the Union. That's the end of the compromise. In other words, there will be no compromise on this issue. So what they do is, right, they send it to a committee, right, and this other committee gets together and they come up with a compromise. They come up with a proposal that is 1800. Congress can't interfere with the slave trade until the year 1800. And now the Southern delegates say, give us 1808 and you've got a deal. Right now they're willing to compromise. That's the result. That's how the slave trade issue in the Constitution comes to be the year that it is, 1808. It's that 20-year gap that the Southern delegates agreed to, when earlier in the month they said we won't agree to any sort of an end date. That to me is sort of incredible that through some political maneuvering that is able to happen. I'm just wondering if any of you could comment on that.
Yeah, thanks. That's fascinating, and that's a good way of describing it. I think that speaks to the general dynamic on a number of the compromises in the Constitution, and particularly these ones over slavery, which is the kind of, do we call the bluff, right, of the Southern states when they say they're going to actually leave over this? Are they going to actually leave and not sign, not be part of the Constitutional Convention anymore? And there's a lot of uncertainty about that. And there's a lot of uncertainty, and I think it's, in a way, it's evidence that you could call the bluff of the Southern states, that they back down from the position of you can never, that there has to be a prohibition on abolishing the slave trade, totally. And then they do back off from that. And so I think some delegates, some anti-slavery delegates, are thinking they'll back off completely, or if we just call their bluff and push it, they'll still join the Union. Even if we push it as far as we can, but then of course it's uncertain. They might have actually left, and they're certainly adamant about the fact that they would. South Carolina and Georgia, the delegates. So it's a really delicate situation, and it does speak to the need for prudence and compromise. But it also does open up these interesting historical counterfactuals. What if the anti-slavery delegates had pushed further and tried to call the bluff of the Southern states? What would have happened? Of course, we'll never know.
With a little hindsight, we know that South Carolina had been drawing lines in the sand for a long time. And so Adam's exactly right that navigating that over a long history in terms of what is the Deep South willing to do with regard to compromises. And so I don't know enough about the going into the bargaining process there of saying absolutely no restriction whatsoever, if that's where you begin, knowing that you're going to chip away at that eventually, or if that is this, I'm sure on the parts of some it's very sincere, on the parts of others I'm sure they're willing to give a little. And so I'd be interested in reading more and learning more, Jason, about that negotiation. That's really helpful. Yeah.
And I think Madison was in favor of getting rid of the slave trade immediately. He wanted it abolished right away. Right. So you see these, right, you've got all these different sorts of human beings with different interests, different opinions, and you're trying to carve out, right, a governing document that they can all or mostly all agree to. And the fact that it happened is, as Madison says, as Hamilton says, it is a miracle.
Yeah, I'm thinking of, this is maybe just a little touch off topic, but I'm thinking things like Federalist Paper of 37, where Madison suggests that we're trying to preserve all these good things and trying to create a constitution at the end of the day is necessarily a compromised political document. And so the beauty of it is that it can be changed, et cetera. The beauty of it is that we want it to endure, but cut us some slack in terms of what we've not given you here is a treatise of political philosophy. What you've given you here is a political document. Constitutions are political documents. And so they're necessarily full of compromises. They're necessarily going to speak to some of these imperfections and these various interests and viewpoints, and trying to make something that we can actually use to govern. And I think that's one thing where when we're thinking about the Constitution on a thing like Constitution Day and some of the compromises it's made, we have to keep that in mind, that it's ultimately a political document. And part of what our politics has always been is trying to engage in politics with a shared dedication to that Constitution, but recognizing sometimes it's going to be a little messy.
Yeah, and in that way, just to point out, I mean, that's one way in which the Constitution as a document is different from the Declaration of Independence as a document. Of course, the Declaration to some extent was a compromise document as well, as we know from Jefferson's draft and the issue of slavery there. But more so, the Declaration was a statement of principle, right? Not a governing political document. And so that's an important difference between the two documents, and opens up, of course, the huge interesting question of to what extent the Constitution as a political document reflects the principles of the Declaration, and to what extent there's some kind of tension there. But yeah, I think that's a really important point, especially as we're coming up on the 250th anniversary of the Declaration of Independence here pretty soon, right? So that's another occasion to reflect on the difference between those two documents.
Yeah, on the point regarding the necessity for political compromise, for prudence, the Constitution as an act of statesmanship. We have a lot of questions coming in about William Lloyd Garrison, who of course is not a fan, or who doesn't seem to be a fan of compromise, at least when it comes to slavery. Right. So his famous line about no compromise with slavery, no union with slaveholders. So when Garrison hears the argument, well, if we don't make these certain compromises with slavery, the union will fall apart and the southern states will leave. We don't want that. Garrison's response is, why not? Slavery is such a gross evil, a violation of the rights of man, that it can never be tolerated. So Garrison's solution, as we see in this document from Garrison on the Constitution and Union, is if the southern states threaten to leave, let them leave. We ought not to make compromises with slavery, because then that taints us with the sin of slavery. There can be no compromise with such an evil thing like slavery, which I think was one of the points we started this webinar out on, is acknowledging that great evil. What are we to think of Garrison, especially in terms of his relationship with Frederick Douglass? I was wondering if one of you or both of you could speak to that, because we've gotten a lot of great questions coming in about the nature of Douglass's and Garrison's relationship. So, for example, was there disagreement over this idea of whether or not the Constitution was a pro or an anti-slavery document? Was that the cause of the breakup between Douglass and Garrison, or was there more going on there?
Adam, I know you brought this up earlier. You might want to get us started, and I'll chime in if I can help it.
Sure. Yeah. Sure. Yes, I think it's really fascinating question. What to make of Garrison's relationship with Douglass. I think that Garrison, what he does is he conflates the Constitution with its effects, or the constitutional text with the constitutional union. So I mentioned that before. I think what Douglass's brilliant distinction was, between the Constitution as a text and the Constitution's context, or its effects, or its historical circumstances. I think that's what led to Douglass's ultimate disagreement with Garrison, was that Garrison failed to make that distinction, and Douglass thought that distinction was important. And I think he was right that that's important. But I think where Garrison really did have a compelling insight was in looking at the Constitution in its effects, right? Not in its text, but in its effects, namely that if there's going to be a constitutional union between anti-slavery and slaveholding elements, that is going to necessitate some level of cooperation and implication by those who are anti-slavery in the institution of slavery itself. So there are all sorts of ways in which this happens, and Garrison sort of relates some of those in this excerpt that we have. But I think that's where Garrison is most compelling, not on his reading of the Constitution itself and the text of the Constitution, but on what the constitutional union means for northern states and for anti-slavery people, and for what the effects of the Constitution will be. And so one example of this that just struck me recently is John Brown's raid on Harper's Ferry, right? So you have John Brown trying violently trying to abolish slavery, trying to do something that will lead to the abolition of slavery. And you have the power of the federal government, troops led by Robert E. Lee, coming in to put down that attempt at abolishing slavery through violent means. And if it weren't for those troops, those federal troops, it's unclear what would have happened, right? How successful John Brown could have been, and perhaps he could have effected the abolition of slavery ultimately, or the emancipation of many more enslaved people. And so thinking of instances like that, you can see Garrison's point that even if the constitutional text itself is not pro-slavery or is anti-slavery in some ways, the union that results from the Constitution is implicated in slavery in various ways. And I think that's what Garrison is really upset about, is that effect and that implication of the northern states and anti-slavery states in slavery. And there, I think he does have a valid point.
I'll just add a couple points. In the piece we read from Douglass, he mentions the Garrisonians. And one thing that Douglass does in that piece is draws a distinction between the government and the Constitution. And I think part of his concern is that many of the abolitionists are conflating the two. Adam kind of spoke to this, but he says, why should we assume that if the government has somehow become rotten, that the Constitution is necessarily rotten? In fact, what they're doing is misadministering or misinterpreting that very Constitution. So the solution is not to be indifferent to or even hostile to Constitution and Union. It's to make sure that we elect office holders that read them the way that they ought to be read. And so he gets into this whole notion of, again, constitutional interpretation. And to me, that's really interesting, because where does he wind up? He does it a bit here in this piece, Douglass, but it's a direct response to Garrison. But it's also in the famous speech a lot of us read and teach, What to the Slaves the 4th of July, with the famous Rochester address, where Douglass argues that what's happened is that the North, and especially Garrisonian abolitionists, have allowed themselves or allowed the South to impose upon them a novel pro-slavery reading of the Constitution. They've given up too much to the slave interest to give them the Constitution, that the Constitution is actually part of the arsenal arguing against slavery. And so it's really fascinating. He suggests this pro-slavery reading of the Constitution, you really didn't see it at the time of the founding. It's actually emerged as the South has begun to dig in their heels and people in the 1830s. And so what Garrison and the gang have done is actually given up too much to the other side. They've conceded this part of what should be part of the battle. And so I think all of Adam's points are well made, but that really stood out to me as part of that falling out between the two is largely, and that too, it's about how to read the Constitution, but also if we're talking about statesmanship and prudence, one could argue that Douglass would say there is more prudence and more statesmanlike behavior from the point of view of certain political actors, even if they're not office holders, to recognize that there's a certain extremism that comes with throwing the baby out with the bathwater. And I think that Douglass sees that, and I think he shares that with Lincoln, and that's part of why we see so many similar passages on this between Douglass and Lincoln. What is the famous line that Lincoln suggests, that if we didn't take the good that we could get in 1787, we would have sacrificed the whole. And one point that Douglass makes in response to people like Garrison, and Lincoln makes the same point, is if you are really dedicated to abolishing slavery from the face of the earth, the worst thing you could do is let the southern states go be an empire of slavery to the south of your border. If you don't have a powerful, vigorous, energetic national government, you are never going to abolish slavery in any capacity whatsoever. And so the cause of emancipation is wrapped up with the cause of the Union for Douglass. And I don't think that's the case at all with Garrison. I think it's a short-sighted reading, in my case, taking nothing away from many of the points that Adam made. There's a certain plausibility to some of these things, and I certainly understand some of these arguments, and they come from a noble position, but I think ultimately politically, they're pretty problematic.
Yeah, I think, and that's a great point about Douglass's distinction between the government and the Constitution. I think that was another really good distinction, and I think we see that, of course, in the way Lincoln uses the Constitution in justifying and waging the Civil War, right? That the same Constitution, the Constitutional Union, and the powers of the Constitutional Union that were used to put down John Brown's raid in Harper's Ferry, those same powers are used to fight against the seceding southern states in the Civil War. So Lincoln, in Lincoln's hands, right, the Constitution becomes an anti-slavery document in a way just because he uses his executive power to wage the Civil War, right? So maybe it's not as satisfying of an answer to how do we tell if the Constitution is anti-slavery or pro-slavery, but at the end of the day, to my mind, I think one of the most powerful arguments for the anti-slavery nature of the Constitution is that Lincoln uses his constitutional power to wage the Civil War and to defeat the South. I mean, which is it's tragic and it's unfortunate, but that I think is when the question is finally, in a way, decided.
Yeah, those are all really, really good points. And I think I remember hearing that Douglas and Garrison's relationship also deteriorated over time because Douglas thought Garrison was taking advantage of him, that he was being used as a political sideshow, where Garrison would bring Frederick Douglass out, the former slave, and Douglas came to resent that. But I think he resented more, right, this iron grip that Garrison held onto this pro-slavery Constitution, which, as you gentlemen have remarked, you sort of, you can see it in that way, but that's really just a surface reading. Like, well, okay, the founders owned slaves. They didn't outlaw slavery in the Constitution. The Constitution made certain compromises with slavery. Therefore, it was a pro-slavery document. But as we're finding out as we go through this webinar and this fantastic conversation, there's a lot more than just that surface level reading. In fact, once you get a little bit below the surface, you begin to see, right, how complex, complicated the situation is, and how the Constitution really does begin to emerge, as it did for Douglas, right? The more he studies the Constitution, the more he comes to realize, oh my gosh, this is not a pro-slavery document. This is a glorious liberty document, a glorious anti-slavery document. You just have to go back to the original primary sources and read the documents and read them carefully. We're quickly running out of time here. We've got a question here from one of the members of our viewing audience who asks about that constitutional convention. This question asks that the early conflict at the convention seemed to be between large states and small states. In fact, in many of our college and high school textbooks, we're told that was the real division at the Constitutional Convention, large states versus small states. But this person asked, wasn't it really more about northern free states and southern slave states? Wasn't that the real division at the Constitutional Convention?
Yeah, I'll jump in first with this one. So that's a great question, great point. So there's actually, on my reading of the Madison's notes on the convention debates, it seems that there's a moment during the course of the convention when a shift happens. Initially, the main division is between the large states and the small states. Madison is at pains, throughout that early part of the convention to dissuade the delegates from that position, to show them that it's not true. That, in other words, there aren't interests that unite small states as such and large states as such, and that therefore it's really a false division to be making. So Madison makes that argument over and over again during the convention, and makes it, I think, really, really well. But then part of that argument that Madison makes, and at one point, I forget what the date is that this happens, but Madison says in one of his speeches on this that, no, the division that's most relevant and maybe most important is not between large states and small states. It's actually between southern states and northern states, or between slaveholding states and non-slaveholding states. That's the real division of interest that is operative here. So Madison himself, I think, on my reading, affects in some ways that transition in the Constitutional Convention between the large state, small state to the free state, slave state discussion. Whether or not, what he's doing there, I think there's some debate about that, what his motivations are, and whether he has other motivations, or whether he just sort of, notices that and then it becomes an important division. But it's a really interesting moment in transition in the Constitutional Convention.
Yeah, I think all that's exactly right. And Adam's forgotten more about Madison's notes than I'll ever know, so I'll defer to him. But I'll just say it strikes me that an either or here might be a poor way of thinking about it. That there certainly are issues with regard to large states, small states, and certain interests. It would still be relevant in things like apportionment, how we structure the Congress, et cetera. But to deny the absolutely monumental influence of the slave interest and non-slave interest, how that affects that debate, we'd be naive to downplay that. But I think maybe getting into an either or situation might be unwise.
We are quickly running out of time here. We're down to our final five minutes or so. So I'd like to just very quickly get your thoughts on this last part of the Constitution that deals with slavery, the Fugitive Slave Clause. Let me read this to you. This is Article 4, Section 2, Clause 3. No person held to service or labor in one state under the laws thereof, escaping into another, shall, in consequence of any law or regulation therein, be discharged from such service or labor, but shall be delivered up on claim of the party to whom such service or labor may be due. The infamous Fugitive Slave Clause. What does that say, and how ought we to understand that clause? Is that pro-slavery or anti-slavery?
I'll just get started. I'm echoing here a scholar that we all have read and studied over the years, Harry Jaffa, who once argued he was a tireless defender of the glorious liberty document version of the Constitution. And he very frequently argued that this might be the toughest nut to crack for that argument, that the Fugitive Slave Clause, that any slave that would escape into free territories, escape into a northern state, that state is duty bound to return that slave up back to an owner. This is a protection of slavery, many people would argue. Now, we've got persons, it's not property. There are many small victories here in the language, but this is one that, if we know anything about the debates of the 1850s, what's really motivating Douglass and Garrison in some of these speeches? It's the slave codes at the time that are being passed by Congress to give teeth to what is underspecified in the Constitution. We know we have this so-called Fugitive Slave Clause. How is that enforced? Like a lot of clauses in the Constitution, Congress has to pass laws to bring those things into effect and give them teeth. And so what's really being debated over the Fugitive Slave Codes is the relative harshness of them. And so increasingly, especially because you have this Southern interest in Congress that has this leg up in voting, they're demanding more vigorous national protection with regard to what they see as slave property, so that individuals who had been accused of being escaped slaves, maybe you had no recourse to any kind of claim to rebut the claim that you are. It's like, maybe you're a free man, you've been living as a free man, you've been kidnapped. And you say, no, I'm not an escaped slave, I'm a free man. Well, you have no access to representation, the fines themselves, or the way in which you're treated for the people who are the ones harboring a slave are made harsher. And this is what Douglass, Garrison, Lincoln, all through the 1850s, that's really part of what they're arguing over. And so even if you look at some of the debates going on within the South, between, or say, the Northern Democrats and the more firebrand Southern Democrats, they're arguing over the relative harshness of these slave codes. And many in the South wanted a much more vigorous federal power to actually, as much as we talk about states' rights, many of the Southern states wanted a huge expansion of federal power with regard to enforcing the fugitive slave laws. And so that's what's really bubbling, that's causing a lot of what the South is calling agitation from the abolitionists. It's fighting over the fugitive slave codes. And so I would argue that in the Constitution, that might be the toughest place to make this claim of a glorious liberty document, because it leads directly to these debates about how kidnapped individuals are treated. So it's a really fascinating part of the argument. Adam, I don't know what you think, if you agree with that or disagree with that. But
yeah, no, I think, Jason, I think you basically covered everything I would have said. So I agree with all of that. I think those are great points. Yeah, I wish we could extend this by 2 hours and just keep talking for a long time. But I would just add to that. Yeah, I think everything you said, I agree with. That this clause, it really is in some ways the toughest from the anti-slavery point of view. It partly because it's the part of the Constitution that backs up Garrison's reading the most of complicity of the northern states in slavery, right? The northern states have to be in some sense cooperative and complicit in enforcing slavery for the Union to work. So it does it gives the most support to a Garrisonian kind of reading in some ways. As you mentioned, the 1850 fugitive slave law in particular was egregiously unfair and terrible in many ways. And that's a law, right? It's not the Constitution, but it's a law passed to enforce this constitutional provision, that among other things provides $5 to a judge who finds a accused enslaved African-American to be innocent or not a slave, and $10 if he finds that they're actually a slave. So, I mean, just things like that are just ridiculous, and that's in that law. And it precipitates the Civil War in many ways, because it opens the prospect of the nationalization of slavery, as also happens in the Dred Scott decision, that now people in the northern states and abolitionists and anti-slavery advocates are realizing slavery is becoming more nationalized, or could become more nationalized. And that is a big factor for Lincoln as well in making slavery the centerpiece of his political career.
All right. Well, thank you to you both. I mean, we're out of time here, although I do want to just end here with one final question for both of our panelists, for the benefit of our audience. If you could recommend one or two books, reading recommendations for those interested in learning more about this subject, what books would you recommend?
Adam, you want to start? That's always a hard question because there's so many books, but yeah.
Well, yeah, a good recent one. I mean, yeah, there's so many great ones. I mean, a good recent one is Willence's No Property in Man. That I think is a really good reflection on this topic.
Yeah, on some of these issues, once we start getting into for as this leads to the 1850s and the Civil War, I still think Harry Joffe's Crisis, the House Divided on the Lincoln-Douglas debates gets at so many of these issues about how we understand slavery in the Declaration, how we understand slavery in the Constitution. Also, Fehrenbacher's book on Dred Scott is still a classic. I think people should really take a look at. Yeah.
Great. Thank you very much for those book recommendations and for a fantastic conversation this morning. Thanks to our panelists, as well as to all of you, our participants, for some great questions. If you did not have a chance to take the professional development poll at the beginning of this webinar, would you please do so now? This feedback really helps us to make decisions regarding the types of PD opportunities that we offer for teachers. And so we're going to sit back for about 30 seconds here. You'll see on your screen that survey has popped up again. Please take 30 seconds to fill that out, and we'll come back to you in just 30 seconds. All right, thank you very much. As a reminder, within the next week, you will be receiving an email that will include links to today's readings, suggested further readings on today's topic, and a link to the archived webinar. We hope you will share this information with your colleagues as well as on social media. If you have enjoyed today's webinar, please consider taking an online graduate course in our MAG program, our Masters of Arts in American History and Government. All three of us teach in that program. It's really one of the best experiences of my career, if not the greatest experience of my career, to be able to work not just with colleagues like Jason and Adam, but to work with our fantastic teachers in the classroom, reading these great texts and having these sort of conversations like what you saw this morning. You can find more information about online course offerings, as well as many other resources for teachers, students, at teachingamericanhistory.org or TAH.org. This is the first episode of American Controversies. Our program will return on October 1st, which I think is in 2 weeks, when the discussion will focus on the 14th Amendment. We'll deal with another conversation, another series of documents on the meaning and importance of the 14th Amendment. Thank you again for being here. We hope to see you all next week, and we look forward to the next conversation. Jason, Adam, thank you as always for joining us.
Thank you.
Thank you.
And thanks to all of you out there viewing us online. We'll see you we'll see you next time. Thank you very much.
Thanks again for listening to Teaching American History's webinar on slavery and the Constitution. For more information on our webinars, in-person educator professional development programs, free document library, and graduate program, please visit us at tah.org.